David Whiting joins us once again, your talkback lawyer. When he's not dispensing free legal advice, he's busy running being part of a successful practice in the centre of Melbourne. David, welcome.
Thank you, Raph.
David, running or being part of? Both.
Yeah, both.
Both.
Let's tick both
Tick
boxes.
both boxes.
Yes, yeah.
A little bit of homework of a sort. So, firstly, the federal government's announced some reviews of bits and pieces of law. What do they want to look at and why?
Well, it's 40 years since the Family Law Act came in. It's 1975 piece of legislation, started on the 1st of January 1976. So we've had 41 years of experience, and we've tinkered and tinkered and tinkered and tinkered, and it's now something like 4 times longer than it was when they started, right?
Yes, it is.
No, it's just every time
Yep.
that the judges say, well, we've read it and we think it means this, and then the government says, oh, well, then we should change it. And as we have different governments, we have different views. So One Nation was keen to look at it from the point of view of the fathers, but there are lots of other things that you might look at. But one of the issues is how much it costs and how long it takes. Computers have actually added... both, I think. It's too long and too much. But computers have added to the length of everything. I mean, if you had to type something, it wouldn't be 300 pages.
Is that the reason?
All right?
Okay.
It's more if you were typing it and you had to edit it and you had to do all of those things,
Yep.
actually look for a touch of brevity at that
So you
point.
blame technology?
Technology's certainly part of it.
Okay.
How is it do we filter down? I mean, I can remember a story out of America where discovery was you gave the other side every document that was potentially relevant, and one of the major tech companies actually printed them all off and gave them to them on a semi-trailer. Right? Now,
It's like an FOI request from a government department. It's the same thing. They say, yes, Mr. Epstein, we're happy to grant you your FOI request. That will be $500,000, please. Because
just
that's
for the
how much
photocopying paper.
Exactly.
Yes.
So it's one method.
Same kind of issue. So, but that can't happen. They're currently looking at incarceration rates for Indigenous people.
So this is the Law Reform
It
Commission?
goes to the
would look
Australian
at it?
Law Reform Commission to say, well, is it working? Isn't it? How might we look at making some changes?
So they look at that, then they look at family law. How good are you at predicting what the Law Reform Commission does when they look at something like family law? Have we any idea what they might come up with?
No.
No?
I'm not even going to try.
Not even going to try. Okay.
I'm not even going to try. The other one was it sort of flows from a family law case, a magistrate's matter in Sydney. So I'm not going to say it has a great deal of standing here in Victoria, but it's an interesting observation. A couple got engaged and they said, in the event that this relationship does not work out, we will give back to each other what it was that we gave the other. So if somebody gave a ring, the ring comes back. Now,
Sorry, they had a prenup or a verbal agreement?
they had a verbal agreement, and it would appear to be, the court found that was the agreement, but notwithstanding that was the agreement, the court says that there was no obligation to give back the engagement ring, although there was evidence that the woman in the scenario actually went back, claimed, and was given those things that were given to her
So they
fiancé.
swapped other things,
They
but
swapped
didn't
other
swap
things.
the $15,000 ring.
The $15,000 ring did not go back. So, and the court said, no, it doesn't have to. It should be seen as an unconditional gift. And in this day and age where we all seem to have slightly different views of marriage, where it seems to be more for a good time than a commitment forever, I find that to be a little unusual. But one of the things that the Family Law Act got rid of. There was an action for breach of promise to marry.
Right.
So if you promised and then you broke your promise, there was an action.
Oh, really?
There was also...
That's pre-75.
Pre-75. There was also an action for what's called criminal conversation. And criminal conversation was enticing someone. So if you race off with my fiancé, then the answer might be, I might have an action for damages against you for criminal conversation. That went too. All right?
Wow, what an amazing law. You stole my prospective partner, therefore I can bring a charge against you.
We're
We're not married yet.
Yes.
Oh, what an astonishing law.
Yeah.
they should bring that one back, shouldn't they?
Okay, so you should be making a submission to the Australian Law Reform Commission?
Yep, definitely. And
Okay.
what did you say there, David? Marriage is for a good time, not a long time.
There are
You don't think people take marriage seriously?
I used to do migration law. I don't do migration law anymore. And you'd have a whole lot of people who would apply for spouse visas. And one of the things that was, well, what's the strength of the commitment? No, we still have separate bank accounts. And no, I'm not going to marry him, but he's still my spouse, de facto partner, just not the level of commitment.
So are you casting aspersions on everybody and their
No, I'm not.
commitment?
It was
Right,
simply
okay.
an observation that there were some people who came in and said, absolutely, this is my partner for the rest of my life. We're in this together.
Got it.
And there are a whole lot of people who says, yeah, it's still my de facto partner, but marriage, I'll get married one day, but I'm not sure it's this person.
Okay. Let's get into your questions at 11 minutes past 10. The phone number, of course, is 1300 222 774. Fiona's on the Mornington Peninsula. Go for it, Fiona.
Morning, David and Ralph.
Yeah.
I have two elderly parents who run a farm. They're both in their 90s and they had run several businesses. And they have appointed the four children, the four siblings, as their executors for both their wills. The parents, the businesses, the farms, everything is in Western Australia.
Yes.
And I live in Melbourne. So I'm wondering, what is the legalities around me resigning as an executor? Because I can't see
Your
how
mum and dad still alive?
At the moment, yes.
Oh, when they die, sit on your hands. Don't do anything. And what will happen will be is the court and do your other three siblings live in WA?
One in Victoria and two in WA.
And
yes.
were they all interested in being involved at the right time?
I imagine they will be. I'm not sure.
So what happens, Jennifer, is that you should look at the statement by your parents in the will as not being a commitment binding on you, but rather their choice. We would like our four children to be our executors. When they die and the time comes, it's possible for you to formally renounce probate, under which you say, I've never done anything in relation to the administration of the estate, I never will, and I'm never going to make a claim to be executor. And at that stage, well, you just disappear from the picture.
Okay.
The second way that you do it is you simply say, not now. And in that case, a grant of probate would be made to those who wanted to apply. And the technical phrase is with leave reserved to Fiona from the Mornington Peninsula to come in and prove the will at any time. So you could become an executor later if it was appropriate.
Right.
So,
it's just because I don't have any knowledge of their business working.
well, then the answer would be you're going to rely on the siblings who are involved, and you're not. I'm not asking you to give up your position as a beneficiary, but you're really saying I'm simply, when the time comes, I'm not going to. I'm going to leave it to them.
Right. So you get a lawyer to help you draft that, or you
but sorry, later. It's you don't change your parents' wills. You don't do anything.
Oh no, I mean, but
at the time, someone will come to you and say, "Do you wish to become an executor with your siblings?" Your answer is no. Okay, and then they will make an application for a grant of probate with leave reserved.
Okay.
All right.
Good luck, Fiona.
So nothing you need to do.
Another will question. Greg is in Wantirna. Greg, go for it.
Yes. Hello?
Hello, Greg.
Yes.
The situation is that my brother and I are joint executors.
Yes.
And we have one other sibling who has lived interstate for a long time and is currently overseas. The other sibling is getting a much lesser amount than we are. They're
Okay, so this is sibling number 3. There isn't a sibling number 4 and 5.
No.
Okay, yes.
So it's got both my brother and I very worried and concerned as to what she might do, what the reaction might be, and if she wishes to contest. So we're wondering what grounds or
look, the grounds are limitless, but you start from. Are your parents gone?
Yes.
All right. So and we're talking about, was your mum or dad the last to go?
Dad.
Right, so did Dad have a moral obligation to provide for your sister? Now, a moral obligation takes into account what the relationship and needs. Okay?
Answer is
in the event,
no.
I beg your pardon?
The answer is no. She
And in the event that there was a moral obligation, then one of the factors that you look for is, well, it only needs to be just enough. It's not required to be generous. And you need to discount that by the fact that they're able to look after themselves. So if you and your brother are not doing particularly well, your sister is doing well, has a good job, has property, then the answer might be that an adequate and reasonable and proper provision for your sister in that scenario might be nothing. There is no assumption of equality. Does that help?
Right. Yes, it does.
So what if I was acting for you, and I'm not, I would get your lawyer to write her a letter. Once she says I'm contesting the will, I would be asking her to please explain why you think you need to be provided for differently to the way you are. And I would give her copies of sections 91 and 91A of the Administration and Probate Act. And they take into account, they list the factors that a court needs to address in deciding whether the deceased, your dad, has or has not made a proper provision for your sister. So rather than spend tens of thousands of dollars on litigation, I try and nip them in the bud. Tell me why. And it might be that if you're satisfied with what you're given, then you and your brother might be prepared to give up some of your share. I don't know. But that's where I'd start.
Okay, Greg?
Okay, fine. And it's 91 and 91A of the Probate
Administration and Probate Act, and you can find it at legislation.vic.gov.au.
Good luck, Greg. Al is in Thornbury. Go for it, Al.
Hello, I'm ringing about superannuation in the event of the separation of a same-sex couple. I've got friends who have been together for over 20 years and are in the process of separating. One has a significant amount of superannuation, the other has very little. And I'm wondering what the entitlement of the partner with not much is to the superannuation of the partner with more.
Let's consider it to be property that's taken into account. And so the entitlements get adjusted based on, essentially based on contribution, although there might be an adjustment based on need at the end.
Okay. So you're saying what a person puts in, they get back?
It's not quite that simple. Let's assume that you've got two people who each make $1,000 a week. So they start the relationship with $1,000 a week each and no assets. That's their income. And what they do is they elect to live off the income of person A, and person B salary sacrifices most of that person's salary into super. I think it would be unrealistic to then say, well, I get back all of my super, you can go swing.
Yeah.
It's not as look at what's been contributed to the combined pool.
Okay.
Look at what's been taken out of the combined pool, where and how.
Okay. In this instance, one partner has contributed significantly more. They've been a higher income earner and contributed more both to the property and to the super. So do you think that would be taken into account?
But Al, if you've got, if you look at the older style relationship where the male had the better job and had the income, and the female had what may have made an extraordinary commitment to home, looking after children, all of those things, your proposition is that your contributions are equal. Simply because you can measure one in dollars and you can't measure up the other in the same dollars doesn't mean we don't now recognise them as having the same sort of value.
Maybe the question Al needs to answer is whether or not the partner who contributed less financially to the super needs to go to court to get access.
That may be the case. But it sounds to me if they do go to court, from what you're saying, it sounds as if contributions will be taken into account when we're talking about distribution.
Yeah, but all sorts of contributions, not just, I put an extra $300 into my super every week, therefore, because the $300 that that person put into super meant that there was extra reliance on the income from the person where the money didn't go into super. I mean, I used to look at some family trust accounts and, at the end of the year, the distributions are made half to one party, half to the other party. And then the first party has the credit card. So all of the household expenses are punched by the accountant against the first person's entry. So it looks like the second person hasn't spent a cracker, but in fact, they've gone out to dinner together, they've done things together, they've bought the telly together, the lounge suite together. It's just from an accounting perspective, they've been piggybacked to one.
Yep.
All right. Thank
Good
you,
luck
Al.
to you and to your friends, Al. John's in Maidstone. I think this might be a constitutional question. We'll see how we go. Go for it, John.
Good morning, gentlemen. I've just been reading up on Section 44, and I couldn't help but notice Section 46, which seems to say something along the lines of any individual can sue these politicians in breach of Section 44 for £100 for each day that they sit. Is this correct?
I have heard mention of that any politician found not liable or legally able to be elected might face a fine for each day they sit in office because of the Constitution. Whether or not that's actually legally feasible, I don't think anyone's ever ruled on it. Am I right, David?
I don't know that anyone's ever ruled on it. I think what the federal government says, well, it's really only effective from the time that the court makes a declaration. I think that's intrinsically wrong. I think if you are not eligible now and the court doesn't tell you till next January, you're not eligible now, even if the court makes a decision. The bit that gets me is, how many votes do we need to look at? Is Senator X or Member Y in the majority in a particular vote that was won by one vote? What then happens?
Which piece of legislation was signed by which minister when they might not have been eligible to actually be sitting in the Parliament?
Yes. So I don't know that anyone's really turned their mind to that. You would have thought that if you were being brutally practical, you would say to the Department of Finance, please hold my salary. I won't vote and please hold my salary until this issue gets determined.
John, I think the only answer we've got for you is that this is the most eagerly anticipated High Court decision since the waterfront decision, which I went to a few of those in Canberra, and this is going to be even more important for the political future of the government. So I don't think we've got any answers for you. I'm sorry.
Thank you.
Not much help, are we, John?
No, not much help. I'm pretty sure he's right, though. I've heard reference to the £100 fine.
Yes.
Let's go to Ron in Frankston. Insurance query. What is it, Ron?
Yeah, hi, Raph. Hi, David.
Ron.
The situation is I have a home which I built 14 years ago. I have substantial movement of the foundations, which has caused fairly severe cracking in the brickwork and consequently in the plasterwork inside. I went to the home insurance company. They came out, sent their surveyors out, they sent their engineers out, and some 9 months later came back and, as expected, rejected it as natural earth movement. I guess I have three questions. One is, subsequently, prior to probably the 10 years coming up, in hindsight, there was some indications which never really alerted me, but so the 10 years for the home insurance was up. The insurance company has rejected the claim as being natural earth movement, and I'm just wondering, is there any sort of recourse possibly that I could take or appeal that I could take against either the building insurance or the insurance company?
They're really the same thing, aren't they? I mean, the building insurance is the policy issued by the insurance company.
But no, I mean the new
builder.
The claim against the builder, yes.
Look,
yes.
You get, under a normal contract, you get a 6-year period in which to claim.
Yep.
For building contracts, we give you 10 years in which to claim.
Yep.
And we also allow you to make a claim if you bought the house within the 10 years, even if you weren't the person who signed the contract with the builder. Mm-hmm. And it's 10 years. Yep. There's no logical reason for making it 14 years and 1 day, or 14 years or 10 months or 20 years. It's 10, right? Mm-hmm. The question at the moment, you've got no evidence as to the cause of the shifting. So your starting point, you're saying it's shifted, therefore I'm making a claim. I'm saying it needs to be a claim that's covered by the insurance policy. So you need to find out why it shifted. I mean, you're assuming, well, it shifted within 14 years, therefore it's a building defect, therefore it ought to be covered. No. Prove or establish why, and then see if that reason falls within the insurance policy. And at that point, you can take on the insurance company for rejecting your claim. Okay. And there are also lots of insurance companies that run an ombudsman scheme.
Yes.
There are a couple that run their own, and there's an industry one. You might also have the opportunity of talking to them. But in order to... It's a marketing line, Ron, that people never change their mind. They make a new decision based on new information.
Okay.
All right.
All right. So I should basically get an independent, structural engineer.
Yes.
To do a report, and then if that is similar along the lines of the report which I got back from the insurance company, then I would repair it myself. If not, there may be claim to go back to insurance.
I'd look at one more thing. Yeah. I'd probably ask the person who's doing your report did the construction comply with the law at the time it was made?
Okay.
All right.
All right.
Thank you, Ron.
David. Very good.
Let's have a word to Anne in Ivanhoe. Go, Anne.
Good. Hi, John.
It's Raph
sorry,
and David,
a couple of weeks late, but keep going.
Hello?
Hello, Anne.
Oh, good, you got me, okay. Now, we've had conflicting advice about this, and so I'd appreciate your clarification. Now, we've been told that if you're selling a property, you have to sell within 2 years to avoid capital gains tax. Now, does that mean the contract has to be signed before 2 years is up?
But what's the starting point, Anne?
Oh, it's a deceased estate. I'm still
deceased
living there.
estate is 2 years from death.
Yes.
The date of disposition is the date you sign the contract, not the date you settle.
Oh, that's what we wanted to know.
All right.
Sorry.
And where it gets confusing is that sometimes they're in different tax years, and that adds to the complexity. But the starting point is death.
Yep.
And the 2 years runs out 2 years from the date of death.
Yep.
And the event is the signing of the contract.
So it's not settlement?
No, it's the signing of the contract.
Oh, because we've been told it was settlement when you get all the money.
No, it's the signing. Your disposition is the day you sign the contract.
Oh. So say if she died in November...
November of 2015, you're doing okay. If it was January 2015, you've got a tax bill. Yeah. But again, you then need to say, well, it doesn't, the question is, what was the value of the property at the date of death?
Oh, I see.
So what you would then do, when you prepare the probate application, you have a guess what the value is, and you turn around and you might use your own assessment. You might use a figure on the rate notice, or you might get an appraisal. And when the property is sold, and you now know in August 2017 that the property was worth this amount of money now, then a valuer will be able to go back and say, well, based on changes in values, this was the value at date of death, and you use that for the capital gains tax calculations.
So if she died, say, in June 2016, we don't actually have to sign the contract until, say, early June or something? Like it doesn't have to be settled by June? 2
years. Whichever start it is, it's still 365 days times 2.
Yes, so that's good. Because we've just thought it was settlement. You have when you get all the money.
No,
it's the date
you sign the contract. No, it's the date you sign the contract. If you sign it before the day before the auction, it's the day before.
Yeah.
If you sign it a week later, it's a week later.
So it's just selling. It's just the contract.
It's just the contract, and of course, if the buyer takes advantage of the cooling off period and walks away from the contract, then we simply ignore that transaction.
Okay.
All right.
Right. Okay then.
Thank you, Anne.
Good on you, Anne. And Simon is in Rover with a Section 46 update. Actually, a few people have texted about that. John called. He thought Section 46 of the Constitution might mean parliamentarians could be fined £100. It's been updated, Simon.
Yes, apparently. I also saw the same section. I thought, oh, goody, millions for me. Apparently it was changed. According to Wikipedia, it was changed in 1974, and it was reduced to a single penalty of $200 plus $200 payment for every day after notice of a suit.
Okay.
So it's effectively been changed from we'll take everything you ever owned to slap on the wrist, naughty boy.
And Anna in Sunshine is saying that it was changed after it was used, that section, against a Senator James Webster in the 70s. And that
apparently he was up for $57,000.
There we go. So it's been changed. We'll get to more of your calls. Let's get to some legal questions with Ben in Brunswick. What's your query, Ben?
Hi, guys. I hired a car a few weeks ago, and when I dropped it off, the person at the car company looked it over, and they said it was fine. You're free to go. Later on in the afternoon, I received a call from them saying that while they were washing the car, they discovered a crack on the windscreen. They sent me a photo of it, and the crack could only be seen when the windscreen wipers were pulled back. And my claim is that did not happen whilst I was in possession of the car, and that they told me it was okay, and that I was free to go. I was just wondering what sort of standing I had to dispute that.
You have lots of standing to dispute it, Ben, but the contract that you've got with the insurance company favours them, not you.
Mm-hmm.
And that's because there will have been a condition report prepared before you took the car.
Okay, yeah.
Which will have said there were no cracks in the windscreen.
Right, even though it couldn't have reasonably been seen without pulling the windscreen wipers back.
I think that's your argument, is that it simply wasn't visible.
Yeah.
And are they absolutely certain they checked under the windscreen? Their answer will be, we washed the cars thoroughly between each job. We didn't see it then. It wasn't reported then, therefore it isn't there.
Right.
And that's just going to be a factual question.
Okay, all right. And so even though they've told me that it was okay, the car was fine, I was free to go,
yes.
Does that count for anything?
Well, I would need to look at your contract you had with a hire company.
Okay.
My argument would be yours, that was that they inspected the vehicle. But can you imagine that they inspect your vehicle and then they find some under-car damage? Would you say that wouldn't be covered?
Yes.
Yeah.
I would.
Well, I'm not sure that I'd necessarily agree with you.
Right.
But read what the policy says about the time at which they accept the vehicle back and what its condition is.
Okay.
And maybe ask that question, Ben. You could say to them, did you check the windscreen? Did you check under the windscreen
Have you
wiper?
got evidence that you checked under the windscreen last time?
Before you gave it to me.
And did you pay by credit card?
Yeah, I did. Yeah.
And have you looked at the credit card to see whether that gives you cover? Because a lot of them do.
Okay.
There's a lot of not every credit card, but a lot of credit cards give you cover for the excess from a car rental claim.
Oh, okay. All right. I'll suss that out. Thanks very much.
Thank you, Ben.
Good luck, Ben. Let's go to Waleed briefly in Doncaster. Go for it, Waleed.
Thank you for taking my call, and thank you for your work, David. It's about a vehicle that I bidded online in an auction in Perth.
Yes.
Prior to the auction, I called the auction company, and I asked, I've done this before, so I'm double-checking if they still deliver the cars to Melbourne. The lady over the phone said, yes, what's the stock number? I gave her the stock number. I heard her clicking on the computer, and she said, it's $900.
Yes.
And then she said, and I asked her, what if I didn't want this car, a different car? She said, look, every car on its own page, there is a freight calculator. So you can go now and check on this vehicle and on any other vehicle. I went back to my laptop. I checked. There is a freight calculator. I clicked on it. It shows where you want, where to from, and it shows 900. I said, okay then. So I bid it on the car on auction. I won the car. Mm-hmm. They automatically charged my credit card deposit of $1,000. And then they sent me an invoice, and I called them. I said, could you please add the freight to Melbourne to the invoice so I can pay the whole thing? They said, okay, we have to calculate it. They returned back to me. They said, it's $2,000.
Yes.
And I said, this is misleading. You said 900. It's still on the page. It says 900. Sometimes...
Waleed, if you've got a copy of the page that shows it at 900,
yes,
then give them that. That, to me, is your answer.
Mm-hmm.
And if necessary, you could issue a claim at VCAT. Because the vehicle was to be delivered in Victoria, it has a sufficient connection with Victoria, or you could issue a claim in a similar tribunal in Western Australia.
Oh, okay. So just one thing is in that calculator, say this is an estimation, and I told them if it's an estimation, you would expect it's 10% more or less.
Yeah.
Well,
not more than
can I
double.
say I agree with you, Waleed. If it's an estimate, an estimate is not a stab in the dark. An estimate is an attempt to get the right answer. And that would be my argument, would be that your estimates are not estimates, they're guesses. And I relied it on the basis that it was an estimate, not a guess.
Good luck, Waleed. You can tell him you're going to try that one at VCAT. David Whiting, thank you.
Thank you, Raf.
David Whiting, your talkback lawyer. He is here every Tuesday at 10 o'clock, taking your calls for some free legal advice.